Hi there. Let's see here. Let's get everything going. So tonight, I'm going to talk about a man named Stewart Handte. He's been on my channel a few times. And I think there's something wrong with the system. So I'm going to show you guys some information. Push another button here. But yeah, so I'm going to share some information with everybody here about a man named Stewart Handte. He used to be a highway patrol trooper. Retired from that, he became sheriff of Mineral County. He became a chief of police for the tribal police out here. And he's got a little bit of a story. So Mr. Handte became a convict. He got convicted of burglary. And the reason he got convicted of burglary, I don't know how you get from this, but he helped a friend of his with elderly mother that was in a nursing care facility. And Mr. Handte's friend, Roger Hilligus, wanted to take his mom out of the nursing facility, so they did. And somehow that became a crime, and Stewart Handte, that spent all of his life in law enforcement, became a convicted criminal of burglary, and he got a 3-year sentence. So tonight, let's see here. I'm going to share some stuff. Mr. Handte's on parole and probation currently. And there's something wrong with the system. There really is. I don't know how he was as a cop. I've got my own opinions. But I know that right now in life he's struggling, and he doesn't think he did anything wrong. Helped a friend, got convicted. But who got hurt? That would be my question. Don't want to put any words in Mr. Handte's mouth. But here's a parole and probation report from Mr. Handte that says he's violating. And I don't know if you want me to read it to you or if you want to go through it yourself. Let me open it up here if I can find it. It's on the screen, but I can't really see the screen. So bear with me for a second. There it is for me to read. So basically what this says is Mr. Handte failed to comply with his agreements listed in the Interstate Compact application. And if you guys watch the channel at all, I went down and did a public records request over at Parole and Probation on this information here that got submitted to the court. Because what this form is got submitted to the court that says Mr. Handte's been a naughty man. Hasn't been doing what the government wants him to do. Evidently, he's been sending some text messages to Story County Sheriff Cullen. If anybody wants to do some public records requests to Story County Sheriff Cullen, get the text messages. I haven't gotten those yet. I haven't gotten any records requests back that I've sent over, other than they've denied me. The one that's really interesting thing here is it says the pattern of concerning behavior continued April 29th, 2025, when the division received a complaint that Mr. Handte was harassing Laura Gray, his father's guardian, and Lila Fons, a nursing director. The California supervising officer was again informed right away. So he was, Mr. Handte's being accused of harassing his father's guardian. But from what I've been told, Mr. Handte told me this, and I've tried to confirm it. Mr. Handte's father died in October of 2006. Mr. Handte's father's been dead for 19 years, but evidently he's got a caregiver that Mr. Handte's been harassing. What do you guys think? Does that sound like a reasonable thing? So let me try to share some more information here with you with this case in Washoe County, Nevada, where it seems like we're, just not quite doing things the way we should, in my opinion. Okay, and if I do this, and there's this one. Let's bring that one up. Okay, this is just the second page of that report. Also see Mr. Handte's got a TikTok video stating time for all of them to go to the train station. That's a quote. I guess according to the government, Mr. Handte made some TikTok video about sending some people to the train station. So I'm going to play the hearing with Washoe County Deputy District Attorney Amos Steggy prosecuting Mr. Handte in front of Judge Breslow here in just a second for everybody to see. And we'll see what happens here. And what's interesting to me is I've asked for these public records. I've put a video out there. Some people have followed up with it too, I guess, from what I've heard. So the prosecution is aware. Well, they're aware of me. Actually, I'll share that with you in a second. The prosecution, before I play the video, let me get to that too. Let me pull up another video for another thing here for us, because the prosecution, before they brought Mr. Handte in for this little hearing, wrote an email to Mr. Handte's attorney, a man named Christopher Day. And this was the plea offer that they offered Mr. Handte not to go to a hearing about supposedly his bad acts of calling his 19-year-old dead father's caregiver and harassing her recently, I guess. Why would anybody harass a caregiver from 19 years ago? Wow. It just really makes you question the whole thing here. But the stipulations that Amos Steggy, the Washoe County Deputy District Attorney, wants to put on Stewart Handte is defendant shall not maintain any social media accounts nor appear in any social media posts, including YouTube, Instagram, and the like. Come into compliance with financial obligations within 45 days, including restitution in the amount of $184.40, $210. So basically, the government wants him to pay him $862.40. Let's go on to the next screen and see what that one says. Find the next one. Where'd the next one go? Sorry, I'm just not as organized like I'd like to be right now, but here we go. Okay. Let's see here. Let's see if I can move this around to different spots so it's not so. We'll just go this way. For the full term of probation, defendant shall not send blast emails, shall not refer to this matter as a conspiracy, a cabal, or a cover-up. Handte shall make no veiled threats in compliance with probation terms, paragraph 8. Defendant shall not publicly or in any advocacy forum make statements on the topic of court, the 2nd Judicial District, Washoe County District Attorney's Office, Reno PD, any of his arrests in this case, or underlying circumstances of the charged offenses. Excuse me. Seems like a whole lot of this is trying to make it so Mr. Handte can't talk about anything. Let's see here. Let's get this back to a better spot. I can make that. I'm just not having any good luck right now. There we go. That kind of works. For the full term of probation, defendant shall not send blast emails. Okay, this is the one I just read. So let me, sorry about that. Pull up that one. I'm just not having good luck with this thing tonight. Okay. Yeah, this is where it gets more interesting. I think it's this one here. Just can't get rid of this one, can I? Let me see if I can share it a different way here. Boom, 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 boom. It's not the one terms that they want to put on this dude. Well, no, Barry, free speech is dead. In the United States, the government likes to control the free speech because, well, if they control it, they control everything. And if I could just get, there it is, back to the right screen. There it is. And let's see if I can share the screen here with you now about the next part of what he doesn't want, what the government does not want you guys to see. That's it. Here it is. Okay. That's the one I just shared with all of you. Okay. Here's the next page. Still just not having a good luck with this thing. Okay. Defendant shall no promote, participate, endorse, or otherwise post social media videos, including those similar to this little YouTube video right here. Everybody, guess what? That's a little video that Stewart Handte made with me when he and I did a live stream explaining some of the things that happened to him. They're trying to shut him up, and they don't like the video that I made. Anyways, it says, exposing corruption of former cop's bold journey. A defendant shall submit any device to search for compliance with any term. So basically, they don't want him to put anything on social media. They want him to give his device over whenever they want to see it. Says, nor shall he recruit or assist others in public statements. Health, welfare, and the safety of the community. Oops, that's the wrong picture right there. Get that one back up. But anyways, they don't want him to be sharing anything. Let's see here. This is the other thing right here. Here's the really good one. According to Amos Steggy, he doesn't want Stewart Handte acknowledges that due to his probation status, his First Amendment rights and speech topics, including of the court, district attorney, Reno Police Department, nursing home in question, in this case, and social media are limited. Here's the good one. Defendant shall have no contact with Renee Weiler, Drew Rebar. The government doesn't want Stewart Handte to have contact with me because I make videos and show everybody kind of what's going on. They don't want you guys to know what's going on. They want to take this guy's voice away because he's saying, hey, I was in government a long time. The government's really corrupt. Let's not do that. So that thing's kind of crazy what they did right there. Let's see here. So see if I can get this to play for us. And I want to share with you the hearing that happened just the other day.
All rise. Second Judicial District Court, State of Nevada, now in session. The Barry President. Thank you. Good afternoon, everyone. Please be seated. All right, welcome to Department 8. We're on the record in CR 19-1535, State of Nevada versus Stewart Handte. The court recognizes the prosecutor, Mr. Steggy, defense counsel recently appointed Mr. Day, Mr. Hante's present, and I believe it's Officer King. Is that right?
Yes, correct.
All right, thank you. Good afternoon, welcome to all of you. We're here today because the court set a hearing on a notice of technical probation violation filed by the State of Nevada Division of Parole and Probation. Informationally, tomorrow the court is handling 14 criminal justice matters. 5 of them are hearings on probation violation matters. The procedural posture of this is not remarkable, to the extent that if the division believes there's been a technical violation, English translation for that, smaller, modest-sized violation, they file a notice, the court sets a hearing and decides what to do. If the division believes there's been a large, significant, more significant violation of probation, it files a notice of non-technical probation violation. But the process is the same. Mr. Handte's case, no exception. Just like tomorrow, there's a notice, there's a violation report filed. The court sets a hearing. Parties come to the hearing. The court finds out if the division maintains a position it set forth in its violation notice. The defense then advises if it admits factually what the division said happened, makes argument whether the court should deem that to be a probation violation, and if so, how to proceed. Alternatively, if the defense believes that the division has it wrong, factually, didn't happen, happened a different way, doesn't constitute violation, defense has the right to ask for a more formal evidentiary hearing under the Anaya case. So shorthand for that is sometimes defendants accused of violating their probation ask for an Anaya hearing. And then the matter is set for a later hearing. We block off more time. We take testimony if necessary from witnesses. Court reviews evidence that's admitted and then makes a decision whether a violation has occurred, and if so, what to do. In this case, again, procedurally, several weeks ago, the division filed a technical violation report. In fact, the date of the report is September 18th. The shorthand, because everyone can read the violation report for themselves, but the shorthand for the at least 2 or 3 most significant concerns raised by the division are that Mr. Handte allegedly is reaching out directly to people that were involved in his criminal justice or possibly civil justice matters, emailing them, contacting them, posting things about them by name, and using extremely loud rhetoric that calls into question their concern for their public safety. Another item identified in the technical violation report is that Mr. Handte allegedly posted a TikTok video in which, in referring to attorneys or judges or law enforcement people who he believes have wronged him, that it's time for them to go to the train station. That expression being, I believe, taken right out of the series Yellowstone, when it's indicated that if somebody's to be taken to the train station, it's because they're going to be killed and thrown off the train or something similar. So the not so subtle messaging there is it's time for those people to be hurt and or killed. Extremely concerning to the division if this is occurring. And so in a moment, I'm going to ask the officer to identify in a little greater detail what the concerns are. Then I'm going to ask the defense if they concede any or all of the factual violations. And if so, how they would have the court respond. And if they do not, then would they ask for a deny hearing? And if so, how much time they anticipate needing? Or anything else for the good of the order? So starting with Officer Kane, what can you tell us about what the division believes are the concerns and how it believes there's been a technical violation of Mr. Handte of his terms of his probation?
Yes, Your Honor. As you're aware, I'm not the author of this report representing the division.
No problem, just slide the microphone. Do the court a favor, slide the microphone just a little bit closer to you, make sure. That's okay.
So yes, according to the violation report,
This cop has nothing. He's got no clue.
May
He didn't
16th,
even write the violation report. He's just there to read it.
Mr. Handte was instructed on directives and conduct along with his other conditions of the interstate compact. Between January and September of 25, there was a recurring concern. January 22nd, the division learned he had been making.
So this whole thing is, they've got these people in Las Vegas that wrote this report on this man that they're trying to control his life. And then they send this guy, because the report was written in Las Vegas, is what it looks like to me. And then they have this guy from Reno come into court to read the report that's got no idea of any of the facts. It's crazy. It's nuts. It's stupid.
Threats against the Attorney General and other state officials. At that time, the investigator determined they were not serious, and Mr. Handte was instructed to cease. On April 29th, the division received a complaint that Mr. Handte was harassing Laura Gray, his father's guardian, and Melissa Fons, the nursing director. His supervising officer in California informed him that a division of probation. On June 12th, the division received a call from Stewart County Sheriff Colin. He reported receiving unwanted text messages from Mr. Handte. This was addressed to Mr. Handte by the California supervising officer. On September 3rd, 2025, the Washoe County Sheriff's Office received a call.
So again, for Sheriff Cullen in Story County, do a public records request from Sheriff Cullen if you guys want to find out what the text messages said.
Call for service regarding TikTok video Mr. Handte made, titled "Set Up to Corruption, Stop Very Cops, Attorneys, and Judges." I do believe that's when the violation report was first filed. That same video was also one where Mr. Handte.
And I did a public records request to Department of Public Safety on this. And they won't tell me anything. They won't give me any information. They say that all their stuff's confidential and they don't have to share.
You say it's time for all of them to go to the train station.
Well, what's the division's understanding of what that means in the context of what's going on here?
The train station comment?
Yeah.
As you stated, Your Honor, it's a reference from Yellowstone, where the Yellowstone ranch workers would take people out, murder them, and throw them off a cliff somewhere in state borderlines where they can be found.
But first taken to the train station, I assume.
Correct.
All right, then what next?
Last one, most recently, September 4th, 2025, email was sent to several recipients, including Roy Strawlaw. Mr. Handte refers to this attorney as a useless piece of garbage and criminal cabal. The email stated rhetoric such as, "I'm not a man of violence, nor do I threaten any type of violence or threats thereof, but I am a man of conviction and will continue to do my diligence to bring down the criminal cabal which you are a part of. Your disgrace to Sigma Nu fraternity and absolute atrocity to alumni of the University of Nevada, Reno." This email was brought to the attention of the division, resulting in this violation report.
So is it the division's position that if some or all of these things are found to have occurred, it would constitute a technical violation of Mr. Handte's probation?
Correct, Your Honor. And ask for a recommendation of modifying.
Okay, so in the event we either if the defendant today concedes that this happened, and if the court finds a technical violation, the division is not asking the court to revoke Mr. Handte's probation, not asking the court to remand him to custody of the sheriff for an incremental punishment, time at the Washoe County Jail, but something else. What's the something else?
They just want to take his right to free speech away. They don't want him to be able to criticize him. They don't want him to be able to shed any daylight on anything or give the people any information. So that way we, the people, can't make up our decisions based on information that we freely get. We only get information that the government gives us. That's what this is all about, so the government can control our speech.
Sure.
We asked that his social media privilege be revoked and he be verbally admonished, and he ceases to do those kinds of communications.
Well, one of these is a text, so that's not social media, that's just text.
Correct, communications with parties.
Okay, Mr. Handte, excuse me, Mr. Stakey, before I talk to the defense on what their position is on this, what's the state's position, please?
I endorse the recommendation. I think that we should all pause to remember that the court has the ability on this violation to send the defendant to jail for up to 30 days.
Well, if it's proven.
If it's proven.
Right.
And so I think it's useful also to remember why we're here. This defendant engaged in a crime in which he thought either the law did not apply to him because he had special privileges as a former, I'll use the word, law enforcement officer, or he relied on obviously fake legal documents. And so we get to sentence, and of course the history of the litigation up to the defendant's admission to guilt is that it was this stuff. It was harassment, it was vexatious litigation, it was engaging with others to encourage.
Vexatious litigation. That's what they're saying in my case. Anyways, I don't want to get too much into my case with Washoe County right now. I'll get that in a little while. Vexatious. They just love that word, vexatious. What the heck is vexatious? Trying to fight for your freedom?
Vexatious litigation, fraudulent pleadings, or bizarre and sort of patently untrue legal theories. And so we get to sentencing. And so the court, our statutes and our jurisprudence talk about rehabilitation of the defendant so that he might be the best citizen that he can be. And so part of what we're trying to rehabilitate is going back.
Best citizen he can be. They're trying to rehabilitate. This guy doesn't give a shit. He makes his 6 figures a year and takes away freedoms, and he just the people to say bad stuff about him.
Back to the underlying facts of the case, it's this sort of bizarre belief in conspiracies, sort of conspiratorial thinking, approaching delusional thinking. And so we get to the court ordered the condition of no contact with people. I'm referring to B1, no contact with the victim, etc. The court personnel, judicial officers, DA representatives, etc. There's also a special condition about inflammatory rhetoric that is 8. Not stated in this summary.
Well, just so we're all clear what you're referring to. So you're looking at the judgment of conviction and the grant of probation, and then the terms of probation that Mr. Handte is to follow.
That the court signed on March 20th.
Which is, again, just to remind ourselves, that was about 1.5 years ago. The probationary term here is a fixed 3 years. So we're roughly halfway through the 3-year probationary term.
Yes, and it's a rather favorable negotiation to the defendant. He has.
Well, hold on. Let me just remind myself. In the event Mr. Handte is successfully discharged, honorably discharged from probation, he's allowed at that time to come back and withdraw his guilty plea, and the judgment of conviction will be set aside, so he'll no longer be deemed a felon. Right?
Right, and so he's sort of on his way to revocation in the state's view or a dishonorable discharge. not stay, also he's behind on his fees and fines. But
Okay, let's think about Stewart Handte for a second. Okay, so he took this plea deal of burglary, got 3 years convicted probation, and at the end of 3 years of probation, as long as everything's gone right, he's not a felon anymore. Case is done, criminal record's gone. He took care of his deal. Now think about this man's history. I think he's in his 60s somewhere. I don't know, Stuart, if whatever, however old you are. He's a retired highway patrol trooper. He did that for 20 years plus, I'm guessing. I don't know the exact numbers. He was Mineral County Sheriff. He was chief of police. To the world, he kept his nose clean, followed the law. Well, as much as cops do, that's a whole other issue. And I'm not saying anything negative, Stu. I don't know. I'm just saying I got a bad opinion. But basically a good guy, keeping his, taking care of his family, taking care of his business, wasn't ever in trouble, but was enforcing laws. In 3 years, he's got to stay clean. And they're saying in 3 years, he can't stay clean because they don't like his speech. They don't like what he's saying. It's all about, not about stealing, not about hurting somebody or beating somebody up or harming somebody or taking something away from somebody else that somebody else has earned. This is about what the man is saying, and what he's saying is about government and corruption and the problems, and they just want to shut him up. It's just disgusting. Just
the
disgusting.
court has authority under 176A 630, aside from revocation, can temporarily revoke, but can also, under 3A, modify the terms and conditions of probation. I think it is appropriate. The question of, I predict argument for the question of First Amendment rights. Now we should always pause and we consider certain restrictions on speech, but.
Well, sorry to talk over you, but before I forget, the court did receive and review a First Amendment rights memo or memorandum of law that was filed by Mr. Day, which were appreciated. But let's just remind ourselves, when you're on probation, your constitutional rights are not, they're relaxed, but they're not asleep. I mean, you lose the right to own a firearm under the Second Amendment. You lose the right to have somebody only search your person, your belongings, your home with a warrant. But warrantless search and seizure is generally a condition of probation, and so your First Amendment right can be curtailed, particularly whereas here there are concerns with the nature, the tone, and the expression here that is offensive, and so that's a concern.
And it's, of course, not the first time he's engaged in this violent rhetoric, this sort of inflammatory rhetoric, which, to remind ourselves, the First Amendment does have limits, and it doesn't protect speech that incites violence. It does not. It's not the first time. It probably fits on one hand, unfortunately, two hands, and number of times the defendant has engaged in this type of rhetoric. The court is absolutely correct. The First Amendment, when you're on probation, it's also recognized by 176A 400 under subsection 1. The court may prohibit the probationer from contact or attempting to contact a specific person, et cetera, et cetera. So, but the court can limit first and otherwise protected speech. This speech directed at threats that's not protected. The court, in fact, already ordered that in the condition. So I would propose that the court, if there's an admission today, that the court add the following special conditions. That now he's already violated. I'm of the position that he's violated the condition on contacting the second judicial district court. I'd also ask that he be enjoined to sort of reflect this rehabilitative purpose, be enjoined or prevented from filing punitive documents or encouraging others to file punitive documents. In this case, recently a number of punitive documents were filed on those persons in a published case, that is a vexatious litigant, so we should, not file, we should only file with counsel. He shall not engage others to file putative documents. He shall not associate or communicate with anyone who has been deemed by a court to be a vexatious litigant. He should, the division of right, social media privileges should be stripped by the court. It does, still has speech.
No Instagram, no TikTok,
No
no
TikTok.
Facebook.
Facebook, TikTok, X, he's on YouTube, there's videos on YouTube,
Yeah, take away all the social media. Don't let him communicate with anybody.
there's instances where it's clear he's associating with others, a sort of conspiratorial community to post videos about people associated with his support. There's one related to your honor that he's inspired with or gotten together with. Because the rehabilitative purpose is this defendant needs to understand the wrongfulness of his actions and to avoid getting back to similar conduct, avoid future problems from this conduct. The emails, sort of blast emails related to this case, should also be prohibited. It's problematic because many emails sent to court staff. The court already prohibited that and wrote back about it. So that to me is the more serious, but sort of underscoring that, putting an exclamation on it. By that would be in the states.
And this attorney's name that's trying to take away Mr. Stewart's right to just communicate is Amos, Amos Stege, Stege, and he works for the Washoe County District Attorney's Office that's run by District Attorney Chris Hicks. Chris Hicks is going to be coming up for election here in the next year. Just remember that if you like this, where to vote.
Added condition. The division should also be granted authority as the officers see problematic relationships develop to add sort of people to the list of people that can contact to further his rehabilitative purposes. And lastly, I'll say, Judge, there is reference to source of mental health issues with this defendant. He lead up to his admission of guilt. There were pleadings reference post-traumatic stress disorder. That should add a condition, seek and maintain treatment for that condition.
Okay. All right, so you heard, so Mr. Day, we've now heard from the division the concerns that it believes are violative of Mr. Handte's probation. We've heard the state's view that in the event that those were proven to be true, then the state has this proposed remedial approach, does not involve the attempt to revoke probation and send Mr. Handte to prison, does not involve at this point incremental restrictions and prohibitions that already exist to take into account what's been happening here. What do you think of all this?
Happen.
Your Honor. I mean, candidly, I'm talking at the bit to argue some First Amendment points, but I don't think that's actually really kind of putting cart before the horse.
Sure.
So I've been going through this technical violation report. My client denies essentially each and every factual allegation.
Denies there's a TikTok video where he makes reference to take him to the train or the train station. I mean, that either exists or doesn't.
Well, for in that, for example, I'm not able to find that as been provided to me. He's
Challenging you.
yes, challenge.
All right.
Visualize some courts want me to do, for example, an allegation of harassing and or Ray, his father's guardian, that number one, doesn't know who that person is. Number two, his father doesn't have a guardian. His father's been deceased for over a decade. So
So they have that wrong. They've confused him with someone else, or they have the wrong person, but for sure, Mr. Handte said, not true.
it's actually impossible.
Got it?
Like, no, the whole list that you've done, even my allegations, so I do think that one thing at this point you said in my hearing.
And have the division prove it if they can.
Yes, and so specifically I would request that leading up to it, they could provide these emails and what was concerning to them, if I can provide that so we have a formal hearing that would help the whole process along. I think that we were entitled to see what the specific allegations are, that I will have access to it either way.
I'm really unfamiliar with what the discovery rules require or local rules of practice, more than Nevada rules of or the Nevada rules of criminal practice with respect to pre and nigh hearing discovery. It could be that there is a bank of information that must be disclosed significantly in advance, so responding party has a fair chance to review and rebut. It could be that the law doesn't require that, and we learned about it on the day of the nigh hearing, exactly what proof there is that the division wants to identify and the state wants to seek to prove. I really don't know. Mr. Stiggy, do you have custom and practice on that, or can you refer the court to a rule of practice or otherwise?
Under the rules, there are no discovery or obligations. I think
How about custom and practice?
custom and practice variable. Most typically, the court suffices, of course, because the rules of evidence, there's no rules of evidence apply. So I don't want the court, I'll tell you, we'll do what we can, but I would resist an order from the court directing this.
Well, I'm not, okay, I can tell you this, I'm not anticipating an order. I'm intesting.
So he just said he's going to resist an order from the court if the court were to force him to give them the information ahead of time. So they don't want Stewart Handte's attorney or anybody's. This is my take on it. Maybe I'm wrong. Let me know. They don't want him to get the evidence that they've got. They don't want him to get the underlying, where was the complaint from Mr. Handte's father's caregiver? Let's put her on the stand and say, hey, did Mr. Handte threaten you or get in touch with you? They don't want to give him any of the link to the TikTok video. There's no link to the TikTok video. They're not, all of this stuff that they're saying, they don't have anything to back it up. And now here this attorney is saying that he would fight to have to give that over. It doesn't make a whole lot of sense to me.
I'm encouraging fair play, and if there's a TikTok video that's referenced here, if it's available, it should be produced. If it's not produced, but it shows up on the day of the night hearing, I'd really like to hear a good reason. If it doesn't exist, or it existed but you can't locate it, let Mr. Day know ahead of time so he's not preparing for a phantom.
Yeah, and I can tell you the suspicion is the
Maybe
report comes out.
he says it's a phantom. Maybe.
And
Well, the report's out. It's been out for 30 days now, so. Okay, and then to the extent you have witnesses, the court would appreciate if you let the defense know, at least a couple of court days ahead of who it would be and what you anticipate they're going to talk about. But am I ordering it? I'm not. Am I strongly encouraging it? The court is.
So he didn't order him to make him divulge his evidence before the hearing, where they could take more of this man's rights away to not communicate with anybody.
The court will have an eye hearing. If in the event the court finds that the division and through its attorneys in the state have failed to prove that there's been a technical violation, then we're done. No further change of status needs to happen. On the other hand, if the state proves to the court's satisfaction a technical violation has occurred, then the court has available to it all the remedies available in such a case. I can tell you that as of today, based on even the concerns raised by the division, it's very telling to the court that they're not asking now for the court to have Mr. Handte, even if these are proven or admitted, taken into custody. But if after the court hears all this, in the event the court does.
So this judge wants to take him into custody. Is that kind of what I'm hearing? Is that what you guys are hearing? Because the prosecutors didn't ask to take him into custody. They just want to shut him up. This is...
Find a technical violation, then all remedies are on the table. So everyone should understand that. Or anything else for the good of the order, other than for the court to direct you to set a hearing. The court starts a murder trial in 2 weeks, and it's going to take 7 or 8 days. It's going to have to be sometime in late November, early December. I'll let you, when the court leaves the bench, collaborate on potential dates. You can talk to Mr. Handte as well to make sure the date and time works for him. He has to be here in person. The court doesn't do these hearings remotely. As, for example, the 5 matters the court has tomorrow, they're all in person as well. Anything else from the state or the division at this point? Anything else from the defense?
There.
All right, court will be recessed. Please set this matter for an aye hearing. Thank you, everyone. All rise.
Okay, so that's what happened. So there's going to be another hearing on November 24th. And they're going to see what the state or the Washoe County District Attorney's Office, Deputy DA Amos Steggy, has to present, and whether Mr. Steggy is going to take away Mr. Handte's right to speak, or maybe the judge will just take away Mr. Handte's freedom. Now you got to remember, he's a retired cop. He's not the youngest guy around. If they send him to prison, would he survive? What's the government trying to do here? And beyond that, here's another weird thing going on in Reno. There's this Reno police commander that was retired, Robinson, I believe he was, and he got arrested for soliciting a minor and got out on like $30,000 bail. I guess he paid $3,000 cash. I don't know all the specifics. That's what I'm recalling. If I'm wrong, let me know. But they're after him, and he's getting a divorce now too. Now, if he's a Kilmo doing those things, no. But maybe there's something else going on about people that know things about other people, and they're trying to shut them up here. I'm just asking the questions. I don't know if that's true or not true, or maybe the guy's just a really bad cop. I've heard things about him that he's been involved in some bad things in town too. So, there's like this whole thing of corruption out there that we all got to watch for and check on. And how do we get rid of this corruption? That's the real question. We got to find a solution for it that works, so that we've got the government working for the people again instead of people working for the government. And good government employees can have the power to ferret out the bad government employees and follow the Constitution and serve the public. That's really what we need in this nation. Thanks for watching, everybody. I appreciate it. Going to get going on you. Like, subscribe, do all that other good stuff if you haven't already done it. And have a great day. Have a great night. Have a great life.